Okay, welcome to Property Law 101. I'm Sara Bronin, and I created the series to help you understand the basics of property law. We consider 4 questions in this series, and today we're talking about the third question, which is using property. So easements is our topic for today. Easements are a kind of servitude, a broad category of burdens on land that you've seen in other videos. And there are 2 kinds of easements. An affirmative easement allows an easement holder to perform some action on the property of another. A negative easement prohibits the burdened property owner from doing something on their property. Typically, easements relate to access, not to possession, an important clarification. The benefited parcel, if there are 2 parcels at issue, is the dominant parcel. The burdened parcel is called the servient parcel, the servient tenement. So you should know the difference between easements appurtenant and easements in gross as well. An easement appurtenant is one that attaches to a piece of land. An easement appurtenant can be transferred to subsequent owners of the dominant parcel, so the subsequent beneficiaries can continue to benefit as it runs with the land. An easement in gross, however, attaches to a person or maybe an entity and not the property. So easements in gross are typically not transferable to other people. Rather, easements in gross are non-transferable, except in the case where easements in gross are given to members of the public for rights of way over public property. Examples of that include public streets or highways or walking paths, especially those that are owned by government. It's important to note that courts will not always treat something that we call an easement, nor will it necessarily treat something that we call a lease, or a license. You'll hear more about that in landlord-tenant videos. You know what a lease is, just intuitively or from your experience, and we cover leases again in another video, but leases and easements are different because easements are not possessory. We said before, easements are really about access. You may not know, however, what a license is. A license is a property interest, but it's more like a ticket to a concert or the ability to enter a store. Licenses and easements are different because licenses are typically revocable at will by the grantor, and they don't run with the land. Also, licenses are usually not in writing, but they may be implied by the circumstances. That said, a license may turn into an easement by estoppel, a kind of easement covered in another video, where it might be unfair to revoke it. I raise these issues in talking about the types of easements because it is important to define what an easement is and also to consider how to distinguish it from other legal rights. Courts will almost always want to categorize ambiguous documents or sets of facts based on a specific form, whether it's an easement, a covenant, a license, a profit, or a lease. So lots of things to unpack here. We'll talk more about these in other videos, but for now, I will leave it there. I'd love to connect with you on Twitter through my website, and I will see you next time.